Lucky to have with us today to examine this case a great lawyer named Stone Grissom. He's a criminal defense attorney. He has extensive experience as a civil trial lawyer, and let me tell you, he's achieved every law student's dream of becoming a filmmaker, having won the Best Directors Award at the Montreal Film Festival for students. Welcome, Stone.
Thank you.
You've had cases like this in Seattle. These are tough cases to win. What would you have done differently from what Richard Hirsch did?
Well, I think the unique aspect in this case is the immediacy of the response. I mean, this was not a well-thought-out robbery. I mean, they used a bright yellow SUV, and they walk in with scarves and masks, basically.
Easily identified.
Easily identified. 911 was called immediately. The silent alarm was tripped immediately, and I think that's what you have to emphasize over and over and over again. You might want to start in this case with the murder, to talk about the isolation, how there was nobody around, she was isolated, she was shot. How could this have been prevented? Then back up and talk about all the events that led up to that.
But Hirsch, in his opening, says essentially she shouldn't have run after her alone. Isn't that conceding an essential part of the defense case?
Yeah, he actually makes two concessions which I think hurt the plaintiffs. One, you don't want an officer in a foot pursuit.
Right.
And the other one, I took a note, when she arrived at the crossing, she didn't see or appreciate any other officers there. Now, the standard that they have to prove is that the conduct of the city was it was substantially certain to cause her an injury or death.
And that's a hard
standard. It's like beyond a reasonable doubt in a criminal case.
And especially in cases like this, the best evidence for the plaintiff is kept out, namely that the city realized that they should always have an observer in the helicopter, and they changed their policy after the case.
Right.
But that evidence is not admissible.
Right.
Should it be?
Well, you know, in most jurisdiction, I think in every jurisdiction, what's called a subsequent remedial measure, if they take measures to correct a problem or something that they see, that's inadmissible to prove the negligence beforehand. And the public policy reason behind that is that you don't want defendants, they'll never fix it. If it's always going to be used against them for negligence, they'll never fix it. There is an exception to that. If the defense were in this case to be that it's just not feasible to have an observer, we don't have the budget, we don't have the manpower.
Then you open the door.
You open the door and it's an impeachment process.
But think about what that really does, because it says basically, look, we have a public policy for the future. We want to make sure that the police, for the future, remedy situations like that, so we want to encourage them to do that. On the other hand, you're going to have to suffer the burden of that, because plainly it's relevant.
It is relevant. I think there's a balancing act that goes on. In the public policy reasons, we want people to fix things to the degree that it is to the detriment of the people who might be injured because of that negligence beforehand. You know, it's a bright line rule that they've just made, and we have to live with it.
Right, because you can imagine a city saying to itself, "Look, we between us, we really made a mistake. We messed up here, and we'd like to correct it for the future. But my God, if we correct it, then they win the case, and they're going to get, you know, several $1 million. Let's just not correct it." And you certainly don't want to encourage that.
Right.
Is that one of the reasons these cases are so hard to win? I mean, after all, you got to blame somebody for this death, and clearly DeJesus is the guy who's blamed. He's killed himself, so he can't be put on trial. But once the jury says he's at fault, is it hard for them to say the city's also at fault?
Well, what's good for the plaintiffs is you have a sympathetic plaintiff. You have an officer who was doing her duty, she's protecting the community, maybe overly zealously chasing after this guy, but she's very sympathetic in the way she suffered her death. That's going good for the plaintiff. What's bad is that you have this very, very high standard to say that the conduct of the city was not just negligent, it was substantially certain to cause her death. And that's the hurdle that makes these cases so tough to win. Governmental liability is extremely tough to win. And that's why you don't see a lot of these cases.
Right, but you won your case against the city of Seattle. We've both seen many, many openings and closings. We've now heard at least part of the defense opening. What would you have done different if you had been the lawyer for the city of Tampa? Well,
you know, she does, as you pointed out before, she does give kind of more of a factual recitation, and that might be more appropriate in this particular case because the defense walks a fine line. I mean, they're not there to attack her necessarily, but at the same time, they're also there to attack her to some degree. So I think, the one tactical mistake that she made, or from the defense's standpoint, when she arrived at the apartment complex, she did not radio back to dispatch that she was there. She immediately, for whatever reason, entered into this foot pursuit with DeJesus. that should be emphasized. It was this well-intentioned overzealousness on her part that put her in her own in harm's way.
Yeah.
It was her own decisions that did that. If they can get the jury to believe that there was some negligence on her part, then the plaintiff never reaches that standard of substantial certainty to cause injury or death.
You know, what worries me is that, you know, in a situation like this, if she had succeeded, if she had arrested the guy, if she had shot him, she'd be a hero.
Oh, absolutely.
Nobody would be saying, oh, she was overzealous or she was negligent. It's only kind of Monday morning quarterbacking, and it's Monday morning quarterbacking after the funeral, which makes it so difficult. I would hate to be the city lawyer blaming this on the deceased officer who was trying her best.
Right, and that's the position they find themselves in. I mean, to some degree, they have to embrace her as a hero. She's a victim. She's a fallen officer who was doing her duty for the community. But at the same time, her overzealousness, her well-intentioned, aggressive position that she took made her put herself in a position where ultimately she was isolated. And that's the defense's position, is that she put herself in a position where she became isolated, and that caused her death, or partially caused her death.
You know, it must be so interesting for a lawyer for the city who are always used to defending the police. Whatever the police do is right. Whatever the fire people do is right. They're always in the business of defending the police. Suddenly, they're pointing a finger. And they're saying, our police officer did something wrong, and the proof of the pudding is the fact that she laid dead. Now, you know, she lay dead only because her vest didn't adequately protect her. The bullet managed to find a place to go through. You know, we're talking about an inch here, the difference between somebody who's dead and somebody who's a great hero, and the city has to focus on that inch, essentially, to make its case. It's a very hard case for them to make.
And what's also tough is that this civil trial follows on the heels of the criminal trial for Paula Gutierrez, and so the city just, in one case, she's the victim, she's the, you know, the poor victim that, the officer that just got slaughtered, and in the other case, she's causing her own death to some degree.
Yeah, but you know, the city has the advantage of a lot of jurors think only one thing causes a death, and they've already decided, a different jury to be sure, but we know who was at fault here. It was the dead robber and his imprisoned girlfriend. Do we really have to now find that somebody else was also at fault? Sometimes that's a little hard for juries.
Right, and what the plaintiff needs to point out to the jury is that DeJesus, even though he's the one that pulled the trigger, he was just the bullet. But the city allowed this out-of-control individual, this horrible, horrible individual, to run havoc. It's the same thing when you sue the state or the Department of Corrections or parole agencies for failing to supervise a felon.
That's always tough. That's always tough when you have those omission cases, failure to do. We're going to see how the lawyer for the city continues her opening argument in a second, but right now we're going to take a break. It's the battle of the openings in this case.
Well, I mean, we didn't see the full extent of the plaintiff's opening, and I think if they really hammered the immediacy of the response, and just how quickly the police were notified, and then what the plaintiff really needed to do in their opening is show that this was this elongated chase through the cemetery, back through the, I mean, plenty of time for the police to set up this perimeter, plenty of time for the helicopter to get over there and observe and make those decisions and help protect her, and that failure is what caused her death. If they can emote that real emotional response, and I think the plaintiff would have an edge. I think from what we've seen, the defense has an edge because of the high standard. I mean, I think they've clearly shown that there was a tactical mistake, and unfortunately, well-intentioned again, but partly her fault.
Right. You know, in my experience, I think a lot of lawyers, particularly in criminal cases, this is a civil case, overestimate the impact of the closing and underestimate the impact of the opening. Sometimes lawyers, and I criticize them whenever they do it, waive their opening and reserve, you know, it for the close of the prosecution's case or the plaintiff's case. I think that's a big mistake. I mean,
even in voir dire, we talk about first impressions mean so much. Openings are absolutely critical to any case, especially a complex case.
Oh, yeah. And my one criticism, I think, of both openings were they were a little bit technical and a little bit complicated. I didn't get the kind of emotional impact. The defense opening, at the very least, started to lay the foundation for the witnesses, and obviously the witnesses are now coming. If you were plaintiff's lawyer, defense lawyer, what kind of witnesses do you think you would call in a case like this?
Well, I think in the plaintiff's, you have to make a decision. Do you want to start with the crime itself, with her murder, or do you want to start with the immediate response? If you want to start with the immediate response with the bank robbery, you want to call people to show how quickly the police were contacted. I mean, the silent alarm was tripped as they were walking in the door. 911 was called as the robbery was occurring, and I think you want to establish that and create just how horrifying I mean, terrifying these people were.
Yeah.
And then you want to bring yourself into what should have been done, how much time. You want to really, from the plaintiff's perspective, you want to lengthen out that time to give the police, the city of Tampa, enough time to establish that perimeter, and the failure to establish that perimeter is what caused her death. So you want to show as many witnesses to kind of even hammering the same points over and over again just to lengthen out that time for them.
Yeah, you know, we don't have time for any more questions, but I wonder why in a case like this sometimes the city wasn't prepared to settle. After all, the demands weren't so great. She was asking, the family was asking basically for a small amount of money, and, you know, there was probably a little fault on both sides. But look, lawyers like to litigate, and this case went to litigation, and this wraps up our time with you for today. Hey, my great thanks to Stone Grissom for his wonderful insights. You were really terrific. Coming up next on Trial Heat, Vinnie Politan continues